Good afternoon, everyone. Thank you for joining us for the latest in our series of TSCA 3030 webinars. As many of you may know, I'm Tom Berger, a partner at Keller and Heckman, and today I'm joined by my colleague James Vota, who many of you also probably know, who will be discussing with me the pulse-quickening topic of articles under TSCA. I know what you're thinking, what could be exciting about articles, but I think as you'll see, there are lots of things going on with respect to articles these days. So I'll begin by providing what I think is some interesting historical background. In fact, I learned something new yesterday on this in perspective. And James will discuss how the handling of articles is critically relevant to current TSCA implementation. And many of you may have seen an article on this yesterday in Inside TSCA. And so we'll cover some of the points that me and my colleague David Fisher were quoted on in that article, and we'll build on some of those as well. So we'll start with this. Many of you have seen or heard Assistant Administrator Friedhoff's recent comments on articles. At a recent Product Stewardship Society meeting, Dr. Friedhoff made the following remarks, and I won't read this all to you, but basically, if you look through, what she indicated was that generally speaking, articles are subject to TSCA. The law is very clear that when a chemical enters the U.S., whether in bulk form or in an article, it can be subject to regulation under TSCA. And as such, EPA can, and indeed already has, imposed requirements on articles imported under TSCA. I'll stop right there, which is about halfway through this big block quote, and let James address her subsequent comments about knowing what's in products, essentially. And I will argue that James's part of this talk, which the second half addresses more of a departure from kind of historical EPA practice with respect to my articles than mine, some of the supply chain issues. Next slide, please. Let's back up just a bit. And this obviously, we do an entire, half hour on what is or is not an article. And many of you, I'm sure, have seen this article definition is burned in your brain. And it's kind of repeated throughout the regulations and is in the statute. A couple of things here. First, it's kind of interesting to note that this definition doesn't address release per se, but rather it focuses on shape, design, and basically, if you look at that the third sub-bullet, on chemical reactivity. Interestingly, and some of you may know this, the OSHA definition. OSHA has an article definition. The first two prongs are essentially identical, but the third prong doesn't talk about chemical composition or reaction. What it says is basically requires that the item does not release more than very small quantities, e.g., minute or trace amounts of a hazardous chemical, and does not pose a physical hazard to health risk or health risk to employees. So again, the third prong of the TSCA definition focuses on chemical reactions, and the OSHA definition focuses on kind of release and exposure. So an example I used to use many years ago, and I think there's an OSHA, is it the General Carbon ALJ case talks about this. If you have something like a grinding wheel, right? If you use a grinding wheel and you're trying to sharpen, I don't know, whatever you sharpen, a chisel, I guess, right? No chemical reactions, I don't think, would occur when you're using the grinding wheel, but the grinding wheel basically, basically gets atomized and there could be exposure. So I guess arguably a grinding wheel is a TSCA article, but may or may not be an OSHA article. I guess the second point here is, while I suppose this definition is fairly easy to interpret and apply, the examples that EPA has provided over the years, and they do a pretty good job of this, as many of you probably know, in the context of the CDR. And so there's probably, an 8-page document for the 2020 CDR where EPA goes through what is or is not an article. And I think the examples are probably easier to interpret than the language of the definition of itself. And of course, traditional issues, and don't worry, I'll move on here in a second. Printer cartridges tend to come up, films, whether a film is or is not an article, pre-pregs, and I'll just bring up candles. Think about whether a candle is an article. I'll save you the suspense. In EPA's view, candles are articles. Next slide, please. Okay, now let's focus on the statute. As you know, TSCA was enacted way back in 1976 when I was 12 years old, and the statute uses all sorts of terms, as we know, and they're defined in Section 3. But the three kind of key terms for today's talk are substance or chemical substance, mixture or mixtures, and articles, right? Substances, mixtures, and articles. Substance, you know, if you look at the definition of substance and mixture, there are these big long definitions that I won't read to you today, but they're basically common sense definitions. A substance is what you think it might be, and a mixture is basically a whole bunch of substances that are produced other than by chemical reaction, with a few exceptions. Okay, and substance and mixture, you know, do with the old, control F, and you'll find those terms used, dozens, if not hundreds of places throughout the statute. Article, however, is not defined in Section 3 of the statute and is only used sparsely throughout the statute. Now we're at the second bullet. So prior to 2016, article was only meaningfully used in, and I've listed you all these provisions here, and again, and not in any way that basically made it very clear whether an article was in or out. So significantly, other than in portions of Section 12A, which, as you folks probably know, is the export-only exemption, in no case in the statute, and this is critical, is the term article explicitly used in the context of an article being excluded from a TSCA requirement, right? So nowhere in TSCA does it say, hey, this requirement applies except with respect to articles. That's not in the statute. Thus, one could reasonably presume that articles, which necessarily are comprised of substances or mixtures, are fully subject to TSCA, right? Indeed, an article is just, is just a physical form of a substance in the same way, for example, a colloidal suspension is. So there's no reason, I guess, intuitively to treat an article any different than a substance or mixture, because that's all an article is. Next slide, please. So, as I just noted, article prior to 2016, article only appeared a few times in the statute and really wasn't anywhere that's of relevance to what we're talking about today. But that all changed in 2016 when the LCSA added 2 provisions right in the statute that explicitly address articles. And I'm not going to read every word of these to you, but basically Section 5A5, as you know, Section 5 is new chemicals and SNRs. Congress added a new provision that provided EPA with explicit authority to regulate chemicals in articles. Let me paraphrase what that italicized language says. It basically says EPA may require a SNUN. SNUN, it says paragraph 1A2, right? That 1A2 is SNUNs, not PMN. So EPA may require a SNUN if EPA makes an affirmative finding in a rule that the reasonable potential for exposure to the chemical substance justifies notification. So it's critical that that italicized text in Section 5A5 basically allows EPA to require a SNUN for an article, but not a PMN. We'll get to that in a second. Second, we have a new Section 6C2E that allows EPA to restrict chemicals in articles in Section 6 risk management rules, but only to the extent necessary to address identified risks. And James will talk about that a bit as well. So again, now we have 2 specific provisions that have articles in mind. So the question is, do these new sections grant or limit authority over articles? And I think to answer that, you first need to look at how EPA, not Congress, has gone about regulating articles under the regulations. Next slide. There we go. And it's interesting. This reminds me, I'm reading it for a client or somebody, I don't know, probably several years ago. I basically went through all the regs. This was fun. Went through all the regs and see how, how were impurities treated? Or was it impurities or R&D? I've probably done it for both, over my career under the various sections of TSCA. As you folks may know, when you're working a TSCA 8C issue, an 8D issue, a PMN issue, a SNUN issue, the exemptions change between these provisions, right? Probably the longest list of exemptions we have is the exemption for under the PMN rule. I guess you could argue that the exemption for polymers under CDR is more than that, but you kind of go downhill from that. So in any event, EPA has exempted articles from many of TSCA requirements, and I think significantly with sparse rationale and limited discussion. Okay, and this really isn't a slide, but I think this is what I kind of discovered, if you will. Where's the document I'm looking for? It's right behind the piece of paper in my hand. So in 1983, you may recall, 1983, May 13, 1983, it was the final PMN rule, right? We had the 1995 amendments, but 1983 was the original PMN rule. And so here is essentially all EPA says about the article exemption in the 1983 PMN rule, and please bear with me, and I'll paraphrase. EPA says, because it would be enormously difficult for an importer to determine the identity and inventory status of each chemical substance in imported articles, e.g. automobiles, the rule, and that's the PMN rule, does not require persons to submit PMNs on new substances imported as part of articles. All right? Because it would be enormously difficult to determine the identity and inventory status, basically persons don't have to submit PMNs for new substances imported as part of articles. That was essentially the totality of what EPA had to say about articles in the PMN rule. In the SNUN rule in 1984, EPA said a little bit more, and they provided what I think has been characterized as a minimal rationale for the article exemption. And I'll talk about that on my next slide. And the minimal rationale, which I think, of course, is obvious, even though the definition focuses on chemical reactivity, as they pointed out, the rationale for the article exemption for SNURS was that, quote, people in the environment would generally not be exposed to substances in articles, unquote, right? And that makes sense, right? If you have an article, if you have a hockey puck, you're not likely to be exposed to the chemicals that were used to make the hockey puck, which is my historical generic article example. Significantly, however, EPA indicated, again, this is 1984 when talking about SNURS, that it may decide to eliminate one or all of the exemptions from SNURS if EPA decides that a review under a SNUR is warranted, right? And that transitions into my next slide, but I'm not there yet. So let's just quickly go through these. So as you know, when you look through the regs, substances that are either imported as part of an article or formed during the manufacture of an article are exempt from PMN requirements. The second bullet is probably the most important. We have section 40 CFR 721.45F. And as you know, SNURs are basically menus of requirements, but some requirements basically apply to all SNURs unless otherwise specified. And 721.45F is one of those. And so unless EPA otherwise specifies, articles are exempt from SNURs. Section 8 is kind of all over the place. I give one example here. This is in the sub-bullet, kind of 2/3 of the way down, where articles are not exempt for the 8D rule for lead. At least that was a proposed rule, I believe. But articles are exempt from other Section 8A rules. So Section 8 is kind of all over the place for articles. And in Part 707 for export notification, articles are exempt. And as you probably know, articles are generally exempt from Section 13 imports or requirements. So if you're importing lumber, although it may be naturally occurring, but maybe it's got some treating agent in it, you don't have to make a Section 13 import, sir. Next slide, please. So, as I noted in the previous slide, 721.45F, which is the default exemption for articles from SNURs, EPA can make this inapplicable. And in fact, in several proposed and final SNURs over the years, EPA did just that. And you can see there was one way back in 1991. And obviously, many fibers can be articles, so it makes sense to get rid of it there. Mercury, as you know, can be present in certain types of articles as well. So those were kind of the first two. But then starting in 2014 and before and after enactment of the Lautenberg Act, you see EPA increasingly excluding, making articles subject to SNURs, okay? So on that note, I think that's a good way to segue to James, who's gonna kind of take us up to the present.
Hey, thanks, Tom. So Tom sort of run through, I think, the jurisdiction, EPA's jurisdiction over articles under TSCA and the way it's exercised that authority in the past. I think we want to, just touching again, I think we're interested in this topic because of the comments made by Dr. Friedhoff and some of the reaction to that in the trade press, suggesting there's really been a sort of a sea change in EPA policy. And I think that's really not the case, that what she said really sort of confirmed, I think as Tom showed, a long-standing interpretation of what TSCA covers. But next slide, please. But I think what is sort of implicated, though, what's interesting is sort of the context in which she said it. She was talking about at the time about implementation of the PIP PBT rule. And it sort of underscores that while EPA hasn't really sort of changed its policy because of the changes in TSCA, the way the Lautenberg Act is now being implemented after the amendments, there are a lot more opportunities for EPA to consider regulation of articles. So I give you a couple of examples. Certainly there's PIP 3-1, which has gotten a lot of attention, but three of the other 5 PBTs also have express bans on the manufacturing, processing, or distribution of articles containing the subject substance. So we're regulating articles now. I think, well, we talk about why PIP was different, sort of notice and experience, but this is happening now. EPA has 10 more risk management rules underway for the first 10 risk evaluations, at least first round of those risk evaluations. And so certainly as those rules move forward, we can expect that EPA may well regulate articles as they're relevant to any particular condition of use with an unreasonable risk. Next slide. And so it's not only sort of articles are only come in not only on particular regulation of materials, but also on the reporting rules. Really, quite burdensome there as well. We saw 2018, EPA famously passed the TSCA fee rule, and as you know, at the time it actually was implemented in the spring of 2020, sort of became to understand that the burden imposed in trying to get people to report on any of the high priority chemicals in imported articles was too much. It's going to be quite difficult, and so they had to use extraordinary means to sort of save article importers from that kind of reporting. And EPA has since proposed to change that rule, to take out articles, but that's been proposed. That's still pending, and we could have more reporting on that as soon as really as early as next year sometime. The other, even more recently, EPA has proposed reporting on PFAS in articles that produced, imported within the last 10 years. And here, the scope is incredible. We've done a whole 30/30 on this topic, but it's 5,000 individual PFAS potentially covered by the 1,600 or so the EPA has identified, and another other bunch that really only described by chemical formula. So articles remain sort of in play without really any change of policy, just because of the evolving way in which TSCA, as amended, is now being implemented. Next slide. I think that's what I just said. So it's it's going to be increasingly important, given the frequency with which I think articles may at least be in play, at least be considered for some kind of regulation reporting. More than ever for companies to be aware, to the extent that they can, about the chemicals that are in their products. You need this for regulatory compliance, and I'm thinking about the PIP rule, the struggles the companies are having now, sort of coming late to the game to determine whether or not their products may contain PIP, or if they do, what's may be involved in and how long in making substitution. That's really it's an important regulatory compliance piece. But even more forward-looking, as sort of a strategic planning, sort of EPA engagement kind of perspective, to the extent that any of these companies had been aware of PIP being important to their chemical while EPA was developing the rule, there would have been an opportunity to, I think, to deal with these the challenges involved in doing substitution, or at least investigating those up front. It's equally going to be important for any of the chemicals going through risk evaluation. You need to know as a article, a product manufacturer, whether there are important chemicals in that product that are sort of in play as part of risk evaluations, and so may be in jeopardy of restrictions on their use. Can't do that if you don't know what's there. Next slide. And I don't mean to minimize that. I think that is, as Tom was pointing out, EPA has long recognized it can be extraordinarily difficult particularly for the particle manufacturer or an importer, even more so, to identify all the chemicals of the products in its supply chain. A complex article like a car or an engine, may have hundreds or thousands of these sort of individual components. Each of those components may have its own supply chain that may be, several tiers deep. And those tiers, those chains may, particularly at the ends, they may fluctuate quite a bit. They're not static. And the manufacturer itself may be, two or more, the importer may be 2 or more steps away from the manufacturer of the product. So if you are the importer in the end, to able to sort of interrogate that supply chain, is quite difficult. It's quite daunting to try and survey the supply chain and figure out, what may be in there. So it's, I listed some of the examples, I think, of sort of the things that make that difficult, but it's, the number of components, the sheer number of components in sort of sub-assemblies, the number of suppliers. So, particularly, outsourcing in manufacturing has greatly, I think, to a great extent, sort of separated manufacturers from sort of the far details of their supply chains. You've got the number of components. Suppliers are worried about protecting their proprietary formulations, their recipes, their chemical information. It, I think, interferes with their ability to sort of share information in a transparent way. And suppliers are interested in trying to protect their supply chains. They're not interested in sharing with their customers where they get all the underlying pieces, because they may be bypassed in the future. So I think companies, and reasonably, are sort of protective of the details of their supply chains. When, depending on the context, whether something is in or out of sort of relevant for reporting, if it's an impurity, it's that may, depending on the rule, may be important, but if you have to look for impurities, that's far harder than inquiring with your supply chain about things that are only sort of intentionally added. So the context will make an enormous difference in how difficult the inquiry is. Same thing with reporting thresholds. If the threshold is 0, as it would be for PIP, that's a challenge. Whereas if you've got sort of a higher level, as the case for we saw for ROS and ROS declarations on electronic components, you've got a percentage threshold, and something that would sort of correspond with what's typically done with SDS. So it may be, you don't have to change the supply chain, but their ability to sort of draw conclusions is much easier. So these really can interfere or affect, I think, the burden involved. Nomenclature and identity, when you're looking for specific kinds of chemicals. I gave the example earlier of this PFAS proposed rule, where EPA has not just identified particular identities, but instead has said, article importers, here's a chemical formula, sort of an open-ended chemical formula. Share that with all of your suppliers and ask them whether something that might fit this is in that. But that's, as a practical matter, that's a very difficult thing to do. It's you need a different level of expertise to even consider that question. So it again, sort of challenge in trying to collect information even from a willing supply chain. I think another piece that really affects the burden involved is sort of the enforcement consequences of being wrong. If a sort of a good enough try is enough to answer the question, and sort of your lack of knowledge complete knowledge is excused, which to some extent is under Section 8. That may be okay, but if you need to have an absolute answer, the kind of inquiry you need to get to absolute, like absolute quantities, is much more difficult. That the burden of that is much more difficult. Next slide. So I think that I think we need to take a sort of a further look at considering that EPA is going to be naturally going to looking at many more opportunities potentially to be regulating articles. I think it may be a useful time to really drill down on this a little bit and investigate sort of the burden involved. And EPA's long recognized, as Tom was saying, spoken articulately about the challenges involved in trying to identify particular chemicals in supply chains. But a couple of recent statements or actions by EPA call this into question. We Tom mentioned her Dr. Friedhoff's recent speech about articles, and there is contained in there is what I would generously call an overly optimistic assessment of what may be involved in industry in making one of these inquiries, saying that you must simply survey their supply chains to answer these questions. Well, Section 8 requires much more than that, and in most contexts, if there's a enforcement consequence, you need to do more than just that. And there's sort of and I think an unfair, apples to oranges comparison to the process that companies working under REACH have done in identifying SVHCs in their articles. And there, you've got a limited sum of chemicals identified over 10 years who always sort of come into play after a sort of extensive process of, on the registration of intentions and then through the process of being added to the candidate list, over significant periods of time. And there's a percentage thresholds, there's annual weight thresholds, all these things that sort of simplify that. And beyond that, but perhaps most importantly, in some ways, this is kind of a top-down process in that manufacturers are required to notify to their downstream users the chemical content, SVHCs, that may be in the products they're supplying. And I also registration, and registrations has identified all of the uses, of the chemical. So, to compare that to, I think what we have is, it's not the same kind of operation. We don't have the same sort of legal framework for providing these kinds of notifications or registrations. One of the, I think, the very useful, interesting comments that were submitted on the recent PFAS proposed reporting rule was a suggestion by a number of trade associations, perhaps others, that EPI ought to consider developing running a FACA, a advisory committee, to really develop a record on the burdens and costs involved in regulating articles, to put some numbers to this. I mean, for some parts of TSCA, decisions really need to be made solely on the basis of risk, but for firm risk management controls, I think that we also need to consider the costs and the relative benefits of a sort of additional margins of regulation. And a consideration of the costs involved in trying to regulate articles is something that ought to be taken in consideration. In the recent PFAS rule, EPA had no information about this, although they've always said that things are really difficult. They couldn't even estimate the cost or the burden on article importers, and they didn't throw in a number. They just sort of booked it as zero in the ICR. So it's very, EPA was not even sort of addressing, what it cost industry to try and deal with the chemical content of articles. So a public process that would develop a record that might be used across rulemaking might be a very useful tool. Next slide. Tom, did you have any further thoughts?
Oh boy, no, I think you think you covered it well. I mean, obviously, despite I think perhaps a little overreaction to Dr. Friedhoff's statement, articles, particularly with respect to Section 6, are kind of more on the table, I think, or at least have more attention than they had in the past. And I think your comments about burden, James, are very important. Another example that's got nothing to do with articles under 12B, for example, is you folks probably know it's very easy to submit a 12B notice. In fact, you can even do it electronically now. But the amount of time it takes to determine whether you've exported a specific chemical to a specific country can take a significant amount of time. And I think, given the multi-layered supply chains, as you mentioned, James, and confidentiality issues, figuring out what's in your products, again, which was critical to the whole PIP 3.1 issue, is sometimes more than a challenge.
Yeah, and we see lots of other places. I mentioned Rose. I mean, certainly, anyone who's dealing with Prop 65, is the challenges of trying to identify even that sort of a limited kind of fixed list of materials that may be in a product, and people have to great extent have chosen mostly sort of disclose prophylactically where they can, rather than just given the cost and burden of trying to know for sure whether there may be a Prop 65 chemical in there, to just assume that there is and disclose.
Right on time.
Okay. Okay. So thank you. Thank you very much for joining us. We'll do a next TSCA 3030 next November 10th, but immediately following this one, Alesh Bartel is going to perform our Reach 3030 presentation. I think you need to log out and then log back in with the link you would provided. You can certainly register from this link right now if you want to roll over. We also do, my colleague Manish Rath is going to do his OSHA 3030 October 27th. So with that, thank you very much for joining us. And I should say, of course, that this entire presentation, the slide deck, will be available on our website probably by the end of the week for anyone who missed it. Thanks very much.